So, first tier tribunal, property chamber, residential property. There's an extra little bracket as well, if something extra to add in. Just talking about some of the cases that the property chamber deal with, as I mentioned briefly before, they'll deal with any disputes about residential leasehold management, including the ability to pay or reasonableness of service charge payments. They deal with valuations in respect of lease extensions. If you've got a lease, this happens a lot down in London, that you may have a short lease that was only 99 years anyway, and it's suddenly down to 50 or 60 years, and you want to apply to extend it by an additional 50 years or so. So that's something that they will deal with, and valuations of that. Particularly looking at leasehold disputes in respect of service charges and administration charges, that on application you are able to apply to the tribunal. There is a fee depending on what the application is, which could be a few £100 or so. Is the liability to pay a service charge and administration charge, who needs to pay it, when it needs to be paid, how much, etc. Whether there's any ability for the tribunal to dispense with the ability of the landlord or the requirement to consult with leaseholders before carrying out any major works and recharging leaseholders. And this was the case that I mentioned earlier on in the session today. There was a big Supreme Court case, which is the highest court in this country, dealing with the guidance that's been given in respect of what happens about dispensation and if a landlord has messed up slightly. That case was actually quite an interesting one. The landlord is called Dejan Estates, and it's got a number of big houses converted into 4 or 5 flats in London. And they're always in the tribunal because they always mess up on their consultation. And in this particular case, I think there was 4 flats. The works to be carried out, which were major works, which were justified, were about £400,000 or £500,000 from memory. There was 4 leaseholders. And they did the consultation, but they got it slightly wrong. They missed out part of the stage, but more or less it was there and the leaseholders had all the information. But the leaseholders thought that they hadn't been consulted correctly, and they argued that they should only have to pay £250 rather than the substantial monies that they should have paid. And it went all the way through the different appeal courts, and all the way through the leaseholders won and Dejan, the landlord, lost. And eventually at the Supreme Court, that Dejan won, and the court said, why should the leaseholders get a windfall that they don't have to pay for these works that are actually justified? Dejan had got it slightly wrong, so they reduced the claim by about £50,000, and they also were ordered to pay the leaseholders' legal costs of taking all these appeals, which probably was a huge amount of money. But this case is useful for any landlords or managing agents who might have messed up slightly in the consultation, that if they can prove that the works were reasonable and that the leaseholders shouldn't be entitled to a windfall, then there may be some way out of this. So certainly for my landlord clients, this is a really good story and a good case that we can actually rely on in respect of dispensation cases in the future. Historically, I would always say to landlords, if you've messed up, you're not going to get an order from the tribunal dispensing with service. The only times you would get an order for dispensation was if there was some emergency works that needed doing. And an example of that was the London boroughs when they had, I think it was in Southwark, that there was a big fire in a block of flats and there was fatalities, and as a result of that there was various emergency works that needed to be done within a 30-day period because they had various notices served on them by the local authority. And in that case they didn't have the time to consult properly, and they applied for dispensation and that was given. So that used to be the only way that you would get it in an emergency situation. Now that a landlord is entitled to apply for dispensation and may get it in other circumstances now. I have been involved in some cases where there's been arguments about the administration charges that are charged, which could be consent fees for subletting, for example. Are they reasonable? Is the fees that the managing agent's trying to charge for other things, and are they entitled to do that? So again, they can look at those sort of issues as well. Is there anything on those points before I move on?
So my understanding is it has been thought so far that if the Section 20 consultation hasn't been carried out, the leaseholder would only be liable for the £250, but that court decision that you just mentioned basically says the managing company or the is only liable for the damage caused by the fact that they didn't consult properly.
Well,
so if they could have saved a certain amount of money by consulting, that amount that could have been saved by consulting is considered the damage that...
No, it's not necessarily that clear-cut. In the Dejan case, I'm not quite sure where they got the £50,000 reduction from, but it was a figure that they deducted for some reason. But it just gives the landlord the chance to try and reclaim that money, even though they may have messed up on their consultation. So for you as a leaseholder, what you shouldn't think in the future is, we've got this Section 20 consultation correspondence here, the landlord's messed up, so that means we're going to pay a lot less than we should have had to have paid. Because if the landlord makes a dispensation application now, there's a lot more likelihood that the landlord may actually get that dispensation, in which case you may be paying all or a substantial part of that cost anyway, even though the consultation wasn't carried out correctly. So moving on, another thing that they can look at is the liability to pay some sort of estate charge and who it should be paid for. And certainly my house on the South Ferry Quay, we do have an additional estate charge to pay for the whole of the island and other contributions we have to make towards roads, to maintenance of sea walls and various other things. And I remember when I bought that house and my solicitor said to me, "You're absolutely mad to be buying this house. There's almost an open checkbook in respect of maintenance of sea walls. Are you sure you want to do this?" And I'm like, I love the house, I'm buying it. And didn't even really take it into account. As it is, it's never been a huge problem. But you might find that there's the odd little unusual estate charges in there that aren't necessarily common to all estates, depending on where you are. I don't know actually whether, does the Waterloo Dock have an additional maintenance of seawall charges or anything like that? No.
We used to have something there. We used to have a water lease. We used to have to pay for a water lease, which was cancelled after a certain period of time, but Region carried on charging us it.
Right.
Which is unbelievable. There you go. And that was just for having a dock.
Yeah. I'm surprised there isn't, because Wapping have the same issue. They have to pay for the upkeep of the dock wall along their property to British, Canals and River Trust, as it now is, which I presume is what you've done. Yeah. And I know the same is true the other side of Brunswick Dock, and as well the properties along there have to pay for the upkeep of that wall as well.
So keep our heads down.
But that certainly is an element that should be pointed out by a solicitor who's acting for you on purchase, because it's quite unusual and it could end up costing you a fair bit of money. So you can make an application about a variation of those sort of charges. You can apply to very long leases. As I said before, in my right to manage application I'm doing for someone at the moment, so you can ask the tribunal to consider whether the right to manage is being acquired correctly and whether you've completed all the necessary forms. And also you can look at a right to manage if in fact there's an absent landlord who's you can't find, or in fact maybe that they've gone into administration or something's happened, so that they've got the ability to do that. So the powers these days are fairly wide ranging. The tribunal itself and the makeup is quite different than a court, because in a court you just have one judge. In a tribunal you actually have three people. The chair is legally qualified, you have a qualified surveyor, and then you have, they call layperson just, someone. And they take a more active role, that they will go out, as I said, and inspect the properties, which you'll never really get a judge doing. And they're a little bit more hands-on, and the tribunal itself, although you may not think it at the time, is a lot more informal than a court hearing. I certainly had a case for National Bank building. I can't remember whether you attended the hearing, but they were taking evidence just from everyone sitting in their chairs in the audience. You didn't have to go up and give evidence in a witness box, and it was very, very informal the way that they actually dealt with it. So it's not quite as intimidating as going to a county court or a high court. And you do find a lot of people will do the tribunal work or their applications themselves without legal representation. And certainly I have a number of cases where I've dealt with, acted for the landlord, where the individual leaseholder has actually conducted their own case and have done it fairly well. So don't be shy about doing that.
Just a general question, the FTTPC, is that, how is that located legally? Is the decision binding? How can it be enforced?
It's binding, but it's the lower court dealing with decisions of this nature, if in fact you're not happy with the decision and it's a matter of law and they've got it wrong, you then go to, it used to be called the Lands Tribunal, it's now called the Second Tier Tribunal.
Oh, okay, that's just
and if you're not happy with the Second Tier Tribunal decision, then you go into the High Court. So there is still a appeal process. And that's what happened in the Dejan case, that it started off in the LVT, it ended up going into the Supreme Court, and you can't go any higher than that.
But it is a legal body, it's not just, it's not like a mediator or something.
No, it's a binding decision.
Okay. And can previous decisions be used as precedents for other cases, or does each case have to be decided on individually?
On matters of law, then you can deal with other cases on interpretation of leases and things. But with regards to a finding of fact as to whether an individual service charge is reasonable or not, then it's not necessarily binding. But certainly it's useful, and you can go onto the lease website and actually find every single decision that the tribunal has done on all these different issues. And it's quite useful to find out which way a tribunal may have gone in certain issues.
I'm just asking, there was a specific decision where they once said what kind of charges for the consent for letting and for writing to the mortgage lender and so on, but these letters can be reasonably charged.
Yeah, you go into just the administration section of the decisions, and you'll have to scroll through, but there should be something in there that will help you.
One of our weaknesses is legal understanding. Is there such a thing as a central pool of trainee solicitors or volunteers that are happy to give their services either for a small fee or for free?
Not that I'm aware of, no. And you find generally that most firms, it's a very specialised area, and there's very few firms that will actually give free advice, unless you're like me today, giving my time for free.
The only things that I would say is Lease gives free legal advice.
Yes, they do.
On the phone, email, and they will run workshops. They've come to Liverpool and run workshops. In fact, if there are issues that a number of people would like, we could organise for Lease to come again and hold a free workshop. In fact, they've done it every year at our annual conference. They've had solicitors present to do one-to-ones with people. So that is possibly something we will do again this year in June. The other thing is the Law Society in Liverpool there's a voluntary free drop-in centre on Hanover Street. I think it might be in the Gostins building. I can't remember what it's called, where you can drop in and have a conversation. They won't go to court with you or anything like that, but they will give you some advice.
I think I'd just be very careful, because it is very specialised as an area of work, and just be careful who you go and get advice from, and whoever you go to get advice from, ask them how many tribunal cases they've done. Have they done this application before, so you're not their guinea pig for the mugging up on this area of law.
Just something like the lease, because it is, lots of us look at it and we're just like, well, what does that mean? Because it's got legal terminology.
Yeah.
So if we get someone who's got free understanding, rather than paying hundreds of pounds just to have, or somebody can convert it into layman's terms, so that we can then post it out to our residents, so they have a clear understanding as well.
Can I just say, if you're intent on going down this route against your current manager or landlord, then it may be the case that the income, if you have a managing agent in mind to go to next to replace them, then maybe they could assist with some advice, because on the practical steps, because managing agents look at leases every day and they can point out the potential pitfalls to you and say, well, okay, we can get you 90% of the way, but I'd advise you now spend a few £100 with the solicitor just clarifying the remaining points.
That's useful.
And I was going to just mention as well on these tribunals, if you're an RTM director or a director of an RMC, just be careful on understanding how matters can be transferred now from the county court to the tribunal service. And so if you have a particular debtor on your development, and you're giving instructions to your managing agent to pursue the debts through the normal county court process, if they suspect the county court that there's a reasonableness of service charge issue, then they may not wish to deal with it and pass it straight to the the first tier tribunal, and you can open up a real can of worms then, because they may wish to then go back and look at the last 6 or 7 years worth of service charge expenditure, and there may be some risks there. The agent may not have done their job correctly,
Absolutely.
6 years ago, and if the tribunal then has to determine whether or not the service charges for all those years were reasonable, and they find that they weren't, then the debt you're pursuing could get bigger. And so just as a director, you're aware of how robust your case may be before it gets, before you start pressing the buttons, to recover service charge arrears.
That's very helpful, thank you.
Yeah, no, I've got one at the moment that I'm acting for a leaseholder he's an investor, and he's got 4 apartments in a scheme. He's just been sued for service charges in the county court, and so I've immediately told the court this has got to go through to the tribunal, and it has, despite the objections of the landlord. And that was the very first thing that we did. So it's a very good tactic. But the leaseholder in this case has got a point because he's never received any accounts, he's never had any budgeting. So, he's got some very valid concerns that they've not listened to historically. So this is his chance now. And we were notified a couple of weeks ago it was going to get transferred to the tribunal, and I had the clerk on yesterday saying we're coming up to Liverpool and we're hoping to get the first hearing in a couple of weeks, dealing with what their main issues are. So they're quite proactive once they get involved.
I think that's a very important point there as well. Where I live, one of the things we've tried to do in following Engage's principles of democratic, open and transparent and accountable procedures, we produce our own annual report every year as a management company that we give to everybody on site and send out, and we put on our website as well, which has all the accounts in, has the minutes of the last meeting, has the agenda for the following year, says what we've achieved, says what we'd like to achieve in the following 12 months, and has all our directors on it, and all our contractors, subcontractors, also make comments about what they've done on the site and any issues they've encountered. So I think there's a lot we can do that would mitigate against that happening somewhere down the line, because we've all got, where I live, we've got a very disgruntled resident leaseholder who just refuses to pay for no reason, for no good reason. I mean, we have one of the lowest service charges. We deliver an excellent service, but if she had that, she'd be into it immediately, and we'd end up in the LVT. So I think we can look back to when we took over and show how from that day we've been publicising everything.
Yeah.
We've been open about things, and plus we're managing it so well we know there wouldn't be any. But I could imagine how if I hadn't done that, how nervous I'd suddenly be feeling now, thinking, oh my goodness, what on earth would we have to prove in a legal environment?
It's quite, it can be quite challenging, because a leaseholder can dispute every single invoice if they want to. But that's what the first hearing of the tribunal does, is to actually make orders that the leaseholder and the landlord has to produce all the relevant information. The leaseholder has to be specific about their actual complaints, so that no one's time is wasted, or the tribunal's time is not wasted. But I've certainly had some tribunals that have lasted 3 or 4 days, others last a couple of hours. It really depends on what's in dispute and for how many years.